hearings were conducted. Judge Sotomayor herself acknowledged that she could not have received a fairer treatment before the committee. And it's my hope that will set the tones for hearings in the future, that perhaps somehow we have established a new standard of fairness that will guide both Democrats and Republicans as we consider future nominees from the bench. Last week I made clear my intention to vote no on the confirmation of Judge Sotomayor to the United States Supreme Court, and I will do so for several reasons. First, while Judge Sotomayor's record as a judge on the District Court and Court of Appeals is generally in the mainstream, some of her decisions demonstrated the kind of result-oriented decision-making, one that suggests perhaps a liberal judicial activism that has too often steered the court in the wrong direction over the last years. These decisions relate to the Second Amendment, an important provision of the Bill of Rights, not a trivial matter. I think we would all agree. The Takings Clause of the Fifth Amendment, the right to private property rights, and the right to just compensation, and the assurance that private property will not be taken for anything by the government other than for public use. And then, of course, there is the troubling New Haven firefighters case that others have spoken about. And it's not just the decision the judge made without substantial evidence of disparate impact liability. It's also the manner in which, almost dismissively, the judge refused to give what I believe a fair consideration of the firefighters' claims in a way that I would hope every judge, every federal judge would. Second, many of Judge Sotomayor's public statements about judging include very radical ideas on the role of a judge in our society. Some have said we can't consider those, but to consider only her judicial record and not consider other statements she has made about how judges should perform in office, I think, is an incomplete picture. She has said there is no neutrality in the law. She has said that legal uncertainty is a good thing because it allows judges to change the law and to make policy. She said that foreign law can get the, quote, creative juices flowing, close quote, as judges interpret the United States Constitution, and that ethnicity and gender can and even should have an impact on a judge's decision-making. Now, I would concede that those are hard to square with her statement that her sole standard as a judge is fidelity to the law. But that, I think, demonstrates the conundrum with which many of us are left. This committee gave Judge Sotomayor the opportunity to explain the reasoning behind some of her most controversial decisions, as well as some of her public statements about judging, and to allow her to put that into an appropriate context. But I don't believe she cleared up the confusion over what kind of justice she would be, because I have no confidence which Judge Sonia Sotomayor we will see on the Supreme Court. I will vote against the nomination. The stakes are simply too high to vote to confirm someone who could redefine the law of the land from the bench. I know many senators take the position that Judge Sotomayor will not address legal questions from a liberal, activist perspective, and I hope they're right. I also hope that her testimony before this committee represents a teaching moment, a moment that defines our consensus on what the proper role of a judge should be. In the past, we seem to have had very heated disagreements about judicial philosophy and judicial activism. We debated original understanding versus an evolving Constitution. Yet I think a remarkable thing happened during the course of Judge Sotomayor's confirmation hearings. We seem to have agreed that judges should interpret the law, not make the law. We seem to agree that judges should rely upon the original intent of the framers when interpreting the Constitution, not on foreign law or international law. We seem to agree that judges should apply the law faithfully and not move the law in one direction or another based on their own policy preferences. And yes, we agree that judges should be impartial and not pick winners and losers based on some subjective empathy standard, or whatever is in the judge's heart. Mr. Chairman, I think we've come remarkably close to embracing the Hamiltonian standard in Federalist 78, where he called the judiciary the least dangerous branch, having neither force nor will, merely judgment. If that is in fact the case, then I think we will have accomplished much in the course of this confirmation process. I, for one, would find that consensus encouraging. We've defined where the judicial mainstream is, and we've made clear that radical views on judging have no place on the federal bench. And we've set expectations, I believe, for future nominees. Thank you, Mr. Chairman.
Thank